Well, occupational health is always special in the sense that they're dealing with confidential medical information, and that is a particularly sensitive area. So yes, the question of who is in control of the data and the question of when it can be released to the management is still a problem. But data protection law generally has always been a difficulty with occupational health. Well, since the introduction of the GDPR, the most important changes for occupational health are that they have now to be able to prove that they are following the correct policies and procedures, if necessary, to the Information Commissioner in an inspection. So, although many of them have been following the correct procedures in the past, it is necessary now for them to check that they're doing that and to review all the paperwork. One important thing is that they got to be telling employees what they're doing and why they're doing it, either maybe in a leaflet or on an intranet, because it's very important that they're giving information. Subject access, the employees are entitled to a copy of their occupational health records if they ask for them, and that must be given free of charge. They're not allowed to charge anymore. And the time limit now is reduced. It's now got to be given normally within a month. So it's a question of reviewing everything and seeing that you're up to date and your security precautions are good and your software is up to date and so on. Well, if ICO, the Information Commissioner, comes in to inspect, it's a little bit like an HSE inspector. They're going to demand evidence that you're doing what the law requires. And so they're going to want to look at your documentation, they're going to want to look at your policies and your procedures. They're going to look at how you collect and how you keep data, how long you keep data. They're going to look at the privacy notice which you have to give to the employees as to what you're doing and why you're doing it and what you do with their information. They're going to look at how long you are keeping data and when you decide to destroy it and so on. So it's a question of being able to prove that you're complying with the Act, which is very much a question of paperwork and your policies and procedures. The GDPR introduces a new definition of consent, which is different from the common law definition and says that consent must always be affirmative, and the consent is only valid if there's, the parties are equally powerful. If there's an imbalance of power, consent may not be valid. So in fact, what I am advising and the Information Commissioner is advising is that although occupational health should continue to get consent, which they always have done at common law, that they do not need to comply with the GDPR definition of consent, and they should use another lawful basis for collecting and disclosing data. We're not sure about how Brexit is going to affect the GDPR, but it is likely that the principles will not be changed. The Data Protection Act 2018, in fact, incorporates the GDPR into our law, and that will continue after Brexit. After Brexit, it will be possible for the UK Parliament to change the law, but it is unlikely to do so, because if it did, then companies in the other EU states would not be able to send us data, which would be very damaging commercially.